Hi guys, it's me, Teresa again. Except this time I plan to just take a couple minutes of your time to talk about going into an attorney's office and how we do things. Usually we send out a custody questionnaire in my office, and I'm an assistant to a solo practitioner, Attorney Goldstein, here in Lancaster County. We send out a custody questionnaire to get a better feel for what the nature of the subject is and what's happening with the situation that led the person to our office. We sit there and we go along the guidelines of a custody factor. We don't like to see people come into the office and have a moment of not knowing exactly what they want to ask. So what I do is I send them a custody questionnaire email, and this is what I think all offices should move back to doing: getting to know their client on an individual basis, promoting the co-parenting, or promoting the situations that are hard to deal with. And this is what my speech is going to be about. My computer's not working with me today, so just deal with me a little bit. Anyway, topic 1 is basically just explaining when you go into the office and you're dealing with an emotional situation. So us as the legal team have to become your logic. And for the legal professionals that are watching this, it's us returning to the ethical conduct. It's us returning to what we know best for the client and not grandstanding to get that. Returning to the ethical, logical advocacy that's going to benefit that child, that subject minor child in the middle. So what we look at is we look at the custody factors of the case. The custody factors are, in Lancaster County, just basically a way for us to understand what we're doing. In other words, the judges look at certain things and they want to make sure that they do what's in the best interest of the children. They're not there, they're a third party. They're a third party making a big decision. And when we look at the different things that the courts can do. And if a client comes in and they're emotionally distraught, sitting there wanting to use self-help, and they want to sit there and, we as the legal professionals need to return to being that logic and listening to what is happening in their situation, knowing what they can do, and giving them their fact-based options, but explaining to them in a logical way what the benefits are should they decide to follow this. So now I'm going to turn your attention to the custody factors of Lancaster County Courthouse. This is also the PACSA 5328 factors. And they are this. So I'll just go through them briefly. Basically, it's what party is going to frequent, is most likely going to continue and encourage the frequent contact between the partial parent. Was there any present and past abuse in the house? who performed a majority of the parental duties, the availability of extended family, are there siblings in the house that the child is close to, the attempts of the other parent to alienate, or is the child in harm with the other parent. These are things that the court's considering. Which 9 is which party will most likely maintain a loving and consistent nurturing relationship. Number 10 is which party is likely to attend the daily physical activities for the child. What is the distance between the houses? Each party's available to take care of the child in an appropriate manner. The level of conflict between the parties and the willingness to work together. Is there a history of drug and alcohol? Is there a history of the mental and physical condition? And any other relevant factors that the court might deem fit. We look at this whenever a client comes in. These are what an attorney must consider. Is this an extremely emotional level? What can we do as a legal team to represent the client in the best way possible? And sometimes during these emotional times, we as the legal professionals have to choose what's in the party's best interest through co-parenting, through cooperation. If they're using vengeful tactics, it's our ethical obligation to be the logical voice saying stop, saying you must look and come down off this emotional, vengeful tactic that you're using and think about what's in the best interest of that child. And these 16 custody factors that Lancaster County works with, the judges and the attorneys work together for what's in the best interest of that child. And that's what the judicial is trying to overall do. I was a parent, so I know what it's like to walk in to that attorney's office. I know what it's like to walk in and, be all emotional, all just crying. And my ploy is for the legal field and the parents to understand you are going through an emotional side of this. We are coming in as your logical advocates, but we're not going to advocate for you. We're going to advocate for your child. We're going to return to our basic oath that we take to protect that child in the middle. Next, I want to look at the psychology of a shared, and this is by Angelo. Wrote this in 2001 or 2007. This is shared custody statutory factors and considerations. There's a difference between now and what the standard was even back then. So we're going to look at this together, and I'll explain the differences. So the concept is basically the court to promote the best interests of the child. And what you see here is that the myth of the assumption is that they're reluctant to grant equal shared custody. That has changed. More recently, the Pennsylvania courts are moving to grant the 50-50 custody, as mentioned in the other part of this paragraph, as a method to adapting the realities of the modern family. Meaning that even same-sex couples have an equal right. And as you can see, these are the old custody factors, but the courts still look at it as what does the child want to do if the child's old enough to talk. And there have been circumstances where an 8-year-old child has been called in. What about the emotional well-being? Which parent is going to encourage and allow the continuing parent physical access to the child? And each parent have the qualities of the household with the parent. Again, they're the past and criminal abuse. And these are your 16 custody factors coming into play, but there's only 10. So as you can see, a lot of things have changed over the last even 10 years. I think that there has to be an emotional understanding on the legal end that these times are the times where we can make the difference and we can bring that client in and not grandstand. We can tell them their fact-based options, and we can start caring about society in the whole and give up back to what we feel is the logical option for that client. I'm not telling you what to do with your law firm. I'm just saying that emotional client that comes in, we need to return to the basics. We need to return to the ethical. We need to turn to that ethical oath. So my analysis, we can reform the ethical standard, holding our peer legal professionals to opening and compromising and not out to make that quick dollar off the emotional stressful of you, the client, that's going to come into our office. We can also do the review for that ethical standard to be a part of our everyday professional lives, which is part of the oath that all of us take. And that this is one thing that the emotional parent might not understand, but the legal professional will. And this is where we become your logic. And we need to return to that. So I thank you all for listening to my ramblings over the lunch period. I hope you enjoy your handouts. And I hope this makes you really consider when you do go back to the office that, again, the emotional client has the logical-based representation on a highly emotional court proceedings. The initial consultation is crucial to have these factual-based options from the attorney, but only from the attorney. Us as the legal team cannot render any kind of legal advice. And this goes out to the parents too. When you're dealing with the law office, you want to look for the law office that's going to best represent you and who you are comfortable with. But just remember, even the paralegal sitting at the front desk or the receptionist should not give out any kind of legal advice. So in conclusion, my ploy is to the legal professionals and to the emotional parents saying compromise, because ultimately that child in the middle is what's going to matter. At the end of the day, the child is ultimately what is in the court's best interest to look out for, and in the legal profession is what's going to be our best interest to have that dignity and ethical, logical advocacy return to the law.